Good afternoon, ladies and gentlemen. I hope that you had a nice lunch. We will start right away our session on government agreements and initiatives. And the moderator for this session is Mr. Simon Crimpton, editor of Managing Intellectual Property in the UK. Simon, I give you the floor.
Good afternoon, everyone, and thank you for joining us. We'll try and give a lively session to wake you up after the long lunch. I'm Simon Crompton. I'm the editor of Managing IP magazine based in London. We're here to discuss ACTA and other governmental agreements to tackle counterfeiting. I think we can agree that ACTA is an agreement that's been fairly criticised for both being rather secret and also maybe perhaps watered down in the agreement that was finally reached. I think we'll debate the truth of both those elements, as well as asking what the future holds for agreements such as this. We have representatives from both signatories and non-signatories, so hopefully that will give us both sides of the debate. Each of the speakers is going to start with a very short presentation from the lectern here, and we may ask a couple of short questions after each of those presentations. If you want to ask questions after each one, please do so. Just put your hand up and feel free to do that. And we'll have much lengthier discussion afterwards, and I'll save some minutes at the end as well for more general questions if anyone wants to ask those. Just to introduce the speakers then for we have here, we have Mr. Jorge Amigo Castañeda, who is the Director General of the National Office of Intellectual Property in Mexico. I'm going to maybe invite the speakers, when I've given just their brief introduction, tell them a little bit more about themselves and their role in their organizations as well, if that's okay. We have Mr. Koji Onatani, who is from the Ministry of Foreign Affairs, the Economic Affairs Bureau in Japan. Ms. Chandni Reina, who is the Director of the Department of Industrial Policy and Promotion in the Ministry of Commerce and Industry in India. And Ms. Mariana Molia from the European Patent Office. So we're going to have our presentations in the order of starting with Koji, and then Mariana, Jorge, and finally Chandni. And please feel free to give some brief background when you come up to give each of the individual presentations.
Yes. So, good afternoon, everyone. Bonjour. Buenos dias. Thank you for joining us this afternoon. I want to try to make our discussion as non-sleepy as much as possible, since we had a very good lunch, and also we had a very good French wines of geographical indications. But anyway, in order not to make many audience of us sleepy, I would like to. I have no prepared statements. I have just prepared some slides in order to provide as efficiently as possible some of the information about ACTA. But I'd like to make very briefly 3 points. But before entering into those 3 substantive points, I would like to make just one remarks about as a background. So let me start by oh, sorry, I'm not very much accustomed to, yes. Yeah, as a background, let me just start a brief remark on the realities that we face in terms of global business environment and economic activities in today's world. I have just taken up as one example of many of the indicators or descriptions which highlights the very rapid global development of businesses. I have taken up this indicator, which comes from the Global Investment Trends Monitor, which is published by UNCTAD, and the latest figure is released on just 1 or 2 weeks ago. This is a very symbolic figure, I believe, and for the first time since UNCTAD started to release the figure about global investment trends, trends of FDI flows between countries. For the first time in 2010, developing and transition economies received more than half of global FDI flows. Before, it was rather developed countries, industrialized countries who have continuously received most part of the FDI inflows during decades. So it's a very symbolic change of trends, and this change of trends has come with after the financial crisis of 2008. So if we take the figures percentage of FDI inflows that developed countries have received, which is indicated in blue, and that the developing countries received in each year, the share in 2007, more than 2/3 of FDI inflows was received by developed economies. And in 2010, it is more than half that the developing countries received. So more and more, global business is not about boundaries, country nationalities of the business. It's all the more transboundary, closely intricated network of business. And what we need at this moment of global economic crisis, and what we need most, is the strong engine for recovery of growth. That is how to promote, of course, innovation, but also technology transfer, and also business models which build on such technologies, brands. So those all elements are very closely related to the protection of intellectual property. So that is just the first remark I wanted to make as a background. But let me pass on to my real points related to ACTA. I would like to make 3 points. First, why we need effective IPR enforcement. That's my first point I want to address. The second is what governments need in terms of making its interventions more effective to make their enforcement activities more effective and efficient. And my third point will be what is the status of ACTA, steps to be taken in the future. So let me come back to start by my first point. Why effective IPR enforcement is important for, of course, all of us, but why especially for governments? in previous sessions since yesterday, many speakers has highlighted the damages that proliferation of increasing counterfeiting and piracy makes in different aspects. I just highlighted some of them. Proliferation of counterfeiting and piracy damages legitimate business, consumers' interest, including health and safety, but also for governments more directly, there is this aspect of tax-based proliferation of by definition, counterfeiters and pirates, they don't pay appropriate taxes, not only at the border in terms of import duty, but they don't declare appropriately sales tax or income tax or so on. Also, for the business, and the business counts for governments, because what we all need is a proper business environment. But when we don't have effective IPR enforcement, that means legislations are not properly enforced, so transparent and predictable business environment is damaged. Also, one element which has been repeatedly pointed out is proliferation of counterfeiting and piracy provides a source of revenue for organized crime. So I want to underline that governments have legitimate interest and reasons to try to enforce more effectively and properly their IPR law in their country. And that's a global challenge for all governments. So I put on my slides that effective IPR enforcement and particularly fight against counterfeiting and piracy is an international public good. But my purpose is not labeling something. So it's just a description of what I want to characterize, why fight against counterfeiting and piracy is important. I move on to the second point. Then why ACTA? So governments have interest in investing more in effective fight against counterfeiting piracy, but governments need tools. What governments can do to enhance effectiveness. And those tools need to correspond to the challenges they face. And that is to provide tools to formulate the directions or methods that governments can consider adopting. That is one of our motivations that we have tried to engage a certain number of interested countries into this discussion and negotiation of ACTA. So I have just enumerated a certain number of examples, non-exclusive examples of what ACTA tried to provide in terms of tools for governments. So I put challenges we face, common challenges that we face in today's world. First, for example, cross-border proliferation. Like business, counterfeiting and piracy is not a phenomenon in one and each country. It's cross-border proliferation that we need to tackle. So we need, for example, it can be useful for governments to provide their judicial authorities to have the authority to order provisional measures or injunction against not only importing goods, but against goods from entering into the channels of commerce wherever in the planet, and those kind of things. Customs authorities, if they can act against export shipments they have a chance to stop proliferation at their border. I don't go through all the examples I enumerated, but I hope that my slides will be made available through website of this Congress after the meeting, and you have also the ACTA negotiated text on the web of each different participating country to the negotiation of ACTA. So that you have all those materials about ACTA provisions. So without continuing very, very long, I want to just briefly explain where we are now. Negotiations have parties participating to the negotiations. So negotiations have been concluded last year. So now we are preparing for opening for signature of this agreement. And since the negotiations has been conducted on English text, translations into other two languages authentic, which should become authentic text of the agreement, French and Spanish. This translation work is now underway, and we expect the opening for signature in a few months by participants in its negotiations. And of course, since it is an international agreement we are talking about, certainly each government has its own national democratic procedures to before being bound by this agreement. So including Japan, all other participants into the negotiations undertake domestic consultations in view of signing and later formally acceding to the agreement. That's about the procedures amongst the participants into the negotiations. And of course, like today, we are very much pleased to provide additional information to the public, to the countries which have not participated into the negotiations, and we are looking forward to having a very constructive and interactive discussion about what governments can do in making their interventions, making their enforcement efforts more effective in face of different challenges. So.
So thank you very much for giving me the possibility to introduce a cooperation activity today. This morning we have opened the session saying or remind that intellectual property rights enforcement or a weak intellectual property right enforcement can bring terrible or extremely negative effects in terms of economy and in terms of security. We have also said that we have to look at remedies. Cooperation is one of these remedies. I would like to speak today about a cooperation project run by the European Commission and the Chinese government. The IPR2 project for the protection of intellectual property rights is a technical assistance cooperation on IP protection and enforcement in China. This project is co-financed by the European Commission and the Chinese Ministry of Commerce, MOFCOM, for a total amount of 16 million euro and a duration of 4 years. We are now in the last phase of this project. IPR2 aims to improve an effective IPRs in China with technical assistance to the legislative, judicial, and administrative agency and institutions. We know that only an efficient, transparent, and easy, accessible environment for intellectual property protection in China will encourage innovation, will promote economy, investment between Europe and China for the benefit of consumers and for the benefit of the right holders. International exchange and cooperation is one of the aspects of the IP national strategy in China, where China was explicitly asked to encourage international cooperation on IPR enforcement in terms of training and capacity building. The IPR2 project has to be allocated in this context. In fact, the national IP strategy in China was launched in 2008 after many years of negotiation, and the contract between the European Commission and the Chinese government was signed in late 2007. This is, of course, a sign that synergies between China and the European Union to reach a common understanding of intellectual property rights protection and enforcement are an instrument to reach results. The protection of intellectual property rights and a suitable enforcement system are common goals of the European Union and of China. The technical cooperation through the IPR2 project is an instrument to implement specific action and specific activities on the basis of common objectives. This work, or the work of the project and the work, the direction of the project is constantly reviewed through a consultation with the private sector and the right holders and enforcement authorities. Just to give you an example of activities that we run under the project in the enforcement area, we have supported the European Commission in the dialogue for the action plan with, between the European Commission and the Chinese Administration of Customs, GACC, in the dialogue to create a customs network, sharing information and sharing statistical information and creation of network of customs at key airports or ports. China has strongly expanded the international exchange with Europe in the field of intellectual property rights, launching many initiatives, one of them the actual campaign on anti-piracy, launched at very high level, supported by MOFCOM, CIPO, and MIIT. This is, of course, a very positive sign. It's a very positive sign to see how cooperation can be seen as a remedy or as a way for reaching a common understanding on IPR enforcement. Of course, we have always to consider in our cooperation with China that the concept of intellectual property right is relatively new in China. As let's say, the IP word is part of the Chinese dictionary since around 10 years. But the message that we want to pass today is that international cooperation, technical assistance, can be seen as a way to improve our work in the IPR enforcement. Thank you.
Which is one? I think that I will begin by conclusions. I don't know why. Okay. Perfecto. Oh. Okay, thank you very much. I should speak in Spanish, but I will do it in English because if not, we are going to be confused. What is ACTA? ACTA, as you can see, is a plurilateral international agreement. It is not an intellectual property agreement. It is an anti-counterfeiting trade agreement only. So there are lots of legends outside saying that ACTA will block generic drugs into the markets. I cannot see a single line in ACTA saying that. That ACTA will harm the patent of pharmaceutical products or encourage the pharmaceutical patents. You cannot see a single line in ACTA about that. With ACTA, because we have a chapter on digital environment, now the internet is not going to be free, that you will need a credit card to use internet, which is false. You cannot see anything related with that in ACTA. That Wikipedia is not going to be free anymore with ACTA. I don't know if that's a WikiLeaks or Wikipedia. Well, but what is all about? And in my presentation, I will give you some figures on Mexico counterfeiting and piracy, and you will see why Mexico became a part since the beginning. So we need to provide a more effective IP legal framework, but we need to have it internationally, not only domestically or nationally, because Mexico is not isolated from the rest of the world. We have, as Koji-san said, trade with many countries, and we need to have more or less the same protection and enforcement in all other countries, not only in Mexico, for our exporters, of course. We have to share the best enforcement practices through international cooperation. And we do believe that we need new global standards to enforce IPRs, intellectual property rights. It seems to me that TRIPS agreement needs an upgrade. It's a very old agreement. And that's why you see the list of the parties. In the two previous informal meetings, we have but unfortunately, they didn't have the mandate to follow the negotiations. So this is the list of the parties. You can see only two developing countries there, Morocco and Mexico. And why we became a part of ACTA? Because we know that the world is facing an enormous flood of counterfeiting and piracy around the world. This seriously threatens the IPR system, and I may say not only the IPR system, but even investment, technological transfer, security, safety, and more other things. Nowadays, illegal trade is 10% of the world economic business, with earnings, as you can see, of 2 billion, American billions, which are lots of zeros. And economists should be aware of the importance of deterring these kind of losses provided in the economic trade, and that's why we established ACTA. In October 23 of 2007, the President of Mexico himself approved that Mexico go to the negotiations in ACTA, and we made a formal announcement of Mexico participation in ACTA in that date. And in June 2008, we all began the formal negotiations. As you can see here, it is not only on the Mexican Institute of Industrial Property, which is the administrative authority in Mexico dealing with industrial property protection, but with intellectual property enforcement, which is not the same. So protection means that we grant patents or utility models or designs or trademarks, and enforcement means to enforce the law, okay? And in this case, INPI, Mexico, is in charge of enforcing the two laws, the copyright law and industrial property law. And that's why you can see in the left INPI, which is the Mexican Institute of Industrial Property that I head. At the right, you see the Copyright Office, INDAUTOR, that, by the way, was the one in charge of negotiating the digital environment section of ACTA. And I don't see if the Director General of INDAUTOR is here. He should be. Well, you can see the Foreign Affairs Minister. You can see the Attorney General, PGR. You see the Ministry of Economy, Customs, Taxes, Treasury, and the Telecommunications Federal Commission. So this is the group of public offices, authorities, that were involved in the negotiation of the whole agreement. As Koji-san said, we had the final round. We had 11 rounds, I think. And we have the final one in Tokyo, Japan, on September 23 of to October 2nd, 2010. By the way, we have here with us Mrs. Hilda Gonzalez from INPI. She was the negotiator, chief negotiator, that participated in the 11th round of negotiations. So if my moderator agrees, in the section of questions and answers, I think that for the benefit of everybody, we may ask some of the negotiators. I can see negotiators from the European Union, from the United States, from Mexico. We can send questions to the audience. No? Now, why? Well, these are only some effects of counterfeiting and piracy in Mexico. As you can see, we lost 500,000 jobs only in 1 year, 2009. We have $1 billion losses for the industrial sector. And talking about taxes, we have losses, as you can see, of 888 million here on a special tax for products and services. The income tax, we have 327 million losses in 1 year. And the value-added tax, 125 million losses. So counterfeiting and piracy also hits the area on jobs and taxes. And that's why we believe that it is important to be part of ACTA. We have had a loss in 2009 in the area of customs of 9,000 million US dollars 1 year. Software, 1,000 million US dollars 1 year. Music, 400 million. Let me give you one detail here. In Mexico, in 2009, we had 5,000 million songs downloaded illegally with internet. Well, just put $1. And I think that the whole industry of music in Mexico doesn't worth that amount. And films, we have 300 million losses in 1 year. And footwear, 7% of the enterprises already closed. And someone said, well, the industry says, that we have illegal importation or fake shoes coming into the country on the amount of 200 million pairs of shoes a year. If you take into account that we in Mexico are 103 million, it means 2 pairs per people, per capita. I think that we are the champions there. Well, so we need to enhance IP cooperation. We need to promote innovation and competitiveness. And if we do not enforce strongly and effectively enforce IP rights, no one is going to be competitive in the market. And that's why we need to establish stronger legislative standards for IP protection. We presume that by doing that, we will attract foreign and domestic investment, companies, small and medium enterprises, that, by the way, accounts for 98% of all the industry in Mexico, SMEs. So we have to be very careful with this kind of segment of companies. And we, as you saw, we need to increase the tax revenue and foster formal employment. We need like 1 million new jobs a year. But if we are closing establishments due to piracy, I don't know how are we going to create 1 million jobs a year. And of course, that counterfeiting and piracy is not a serious competition. It is totally disadvantage for the companies that pay taxes and hire jobs. So we need to take that away. In Mexico, and according to our legislation and the procedure for this kind of international agreements, the executive branch has to sign the agreement and then send it to the Senate, which has the power to approve it or reject it. And in these months, we will do that, and we will have the ACTA sent to the senators. But the senators already, because some senators, of course, read some leaks in the past, and they are very worried about something. So they created already a working group that will review ACTA. And I think that's very good, because as I said since the beginning, there are lots of things in the air which are not in ACTA and will not be in ACTA, because that's another important thing. ACTA is closed. So anyone coming into ACTA should sign the ACTA as it is. There's no more negotiations, okay? And our moderator began saying the secrecy. Well, let me tell you that in Mexico, by law, we have the obligation of doing this kind of international negotiations reserved for the parties. And just think on one thing that happened when we were discussing ACTA. Korea was negotiated an agreement, I think that with the European Union. Imagine if the negotiations are public. What will happen? What will happen with the strategy of negotiations to the US or to Europe or to Korea? So we have to be careful when we negotiate an international agreement. So we will review ACTA. We will review precisely and specifically the digital environment section, which is not only Internet. Internet is a part. We do not say in ACTA that Internet service providers will become authorities and will go into the private rights of their clients. You won't see a single line saying that. So I think that what we need to do, as Koji presentation said, is to study ACTA before commenting and doing something. You have to analyze ACTA. It is not an easy agreement. It is not. It is very complicated because the subject is very complicated. But we have to do it. Thank you very much.
How do I go to view?
I learned how to do it. Do it. Here. Yes.
Good afternoon, everybody. I would like to begin my presentation by placing the issue of the agreement that has been negotiated recently in the context of TRIPS. The TRIPS agreement that was negotiated in 1995 and implemented, so to say, arrived at in 1995, involved certain gives and takes from developing countries. It involved gives and takes in the sense that the very big give was that it set minimum standards on substantive provisions. Another important aspect of the TRIPS agreement was that it provided for an enforcement mechanism. Now, this was a big give because till then, developing countries did not have the kind of standards and the kind of mechanisms that were envisaged in TRIPS. And at the same time, it has to be put in the context in which we finally agreed to TRIPS. And the context was that the IP is a private right. It is a right which the right owner must, through a mechanism created by the government, try and enforce, as it is a private right. So the governments were enjoined to provide a mechanism, an efficient mechanism, an appropriate mechanism, and the IP owners or their organizers or organizations or their appointees to invoke that mechanism as and when they felt that there was an infringement. There was, at the same time, a realization that countries are different. They are at different levels of development. They are different also in terms of the kind of industry that exists and their aspirations. And in that context, it was this realization that provided the TRIPS agreement with certain flexibilities, or rather I would like to say that they tried not to micromanage a situation. Because internationally, to micromanage a situation where countries are heterogeneous is absolutely inefficient. And in that context, they realized that there needs to be some space, policy space, for countries to develop their IPR regime in the context of their countries. So developing countries would obviously address their issues of development also while establishing an IPR regime which was compatible with TRIPS. A very important component of the TRIPS agreement and something that we hold very close to our heart is Article 7, which says that while we protect IP and there is enforcement of IP, there should be technology dissemination, that public health concerns should be adequately addressed, and in no way should IP be an impediment to access to genuine medicines. Now, all these are things that were there, that there are in TRIPS, and it's an extremely balanced agreement that we have. It provides for rights, and there are certain obligations. There are safeguards as well. So it is not as if the IP owner can initiate action and not have obligations if the action is false. Let us now look at what is now being brought upon in the form of ACTA. Of course, I must mention that, and there is actually no requirement to mention that, is the fact that that TRIPS itself was a multilateral process. It was a long, arduous process where stakeholders, countries were involved for a long process, came to an agreement which, by and large, everybody agrees was a balanced one. The first issue that comes up when you discuss ACTA is the fact that it has been an opaque process. It is a process which is not open to countries outside the closed group. It is a secret. There is secrecy in the negotiations. And I disagree on the fact that secrecy is essential for negotiations. It might be in the case of bilateral trading agreements, but if you are discussing an agreement at the level of a plurilateral setup, which enjoins to create enforcement mechanisms which will actually lead to a paradigm shift as compared to what was mandated in TRIPS, then this is not the right fora to discuss it. And it was a non-inclusive, a unilateral process, as I would like to emphasize again. Now, if you look at the content of this, the content is asymmetric. While TRIPS looks at the entire issue of IP in the context of development, in the context of needs of countries to aspire to a level of development that developed countries have already achieved, the need for technology transfer, and so many other aspects which are touched upon by TRIPS. And here you have an agreement which only talks about enforcement. It only just talks about how to improve enforcement. It is as if enforcement is an end by itself. But it was to be a means to an end, after all. TRIPS said you will provide enforcement. At the same time, there will be technology transfer, there will be public health issues will be adequately addressed, and it was respected that countries are at different levels of development and that they will have to devise an IPR regime which is suitable to them. This is not at all there in ACTA, which is a sad part of it. You look at the provisions of ACTA, and it is said that it's not a substantive ACTA agreement, but we've tried to analyze it preliminarily. I did it before I came for this conference, and I would like to say that a few comments on it. You look at the counterfeit trademark definition. That leaves a lot of interpretational problems. It says that a good is said to be infringed in a country where the procedure is sought to be evoked. Now, this leads to a complete dilemma on where should be the infringement be? Will it be the right holder who will choose where the infringement has to be? Or does it mean that in-transit products goods are to be enforced against, which is not part of, which is clearly not required under TRIPS? Effectively, substantively, you're going beyond what is provided under TRIPS. Similarly, you have a similar mirror provision in copyright piracy. You look at the territory of a country that is defined, you enclose the free zones as well. Obviously, in-transit is being covered in that. And how then can we say that access to medicines will not be affected? Because effectively, as part of ACTA, it covers all IPs. It is not just trademark and copyright piracy. The first few provisions itself says IP is all 7 rights that are there in Section 2 of TRIPS. If you look at the provisions in damages, it actually tells you the nature of evidence that has to be filed, the kind of the kind of decisions that can be taken. It actually gets into the nitty-gritties of deciding what the legal authorities have to do. Again, it is going beyond what was provided under TRIPS, much beyond what was provided under TRIPS. In that sense, it removes the sovereign rights. In a way, it affects it, because here you have a situation where you're already told what action needs to be taken. And it removes the flexibilities, the ability to monitor, to have a mechanism which suits your country's requirements. And what about the safeguards? You have a situation where an IP holder on a mere suspicion can go and raise an issue and get the customs to take action. It's a mere suspicion. And the importer doesn't need to be informed. There is no indemnification if the information is wrong. Now, where is the balance? There are no safeguards. You can't have an IP right, which is a private right, with overriding rights given to the IP holder. Because we are not against enforcement. We are not against IP right holders being provided the right that they need to have, to innovate, to trade, to have a comfort level. And in fact, in my next few slides, I'll tell you exactly how India has improved its enforcement, both in terms of enforcement as well as policy development that has happened. But you cannot accelerate that out of context. You cannot just focus on one aspect and just not look at other aspects of IP. Let us look at how things have developed. In 1995, the TRIPS agreement was signed. In 2005, in case of India, our 10-year transition period ended. We were to comply with TRIPS. In 2006, the ACTA initiative began, Impact initiative began, Secure began in 2007. Now you have all these developments happening soon after. It's obvious that the IP owners they did not get what they wished to get under TRIPS, and it was soon after that they started off with their plurilateral agreements to increase IP enforcement. And in 2016, you have LDCs to comply with TRIPS. So it's even before they can comply with TRIPS, they will have to face an economic environment which provides IP protection much greater than what was ever mandated under TRIPS. If we look at the Indian experience, we signed TRIPS in 1995. We've met our obligations in that. And while we amended our laws, we also took into account the conditions of a country and our aspirations. And to do that, we in fact went TRIPS Plus in many of our provisions. Be it the Copyright Act, be it the Patents Act, we have gone beyond what was mandated under TRIPS. In fact, if you look at the administrative mechanism, the implementation framework on enforcement also, we have a Copyright Enforcement Board which monitors enforcements on copyright. We have an interministerial group on enforcement which looks at enforcement as a whole. And IPR cells were created in each of the 28 states. India is a federal country. It has a federal setup. There are 28 states and 600 districts. Each state has an IPR cell in the police department. There are ongoing programs for capacity building, for enforcement agencies, for judiciary, for creating awareness, for building respect for IP. And there has been a calibrated progression in policy. So we amended our Trademarks Act last year to comply with the Madrid Agreement. We are in the process of amending our Copyright Act to take into account the developments in the digital environment. What shape it takes finally is of course, it'll come when it comes because it is in the Parliament. But the fact that the amendment is being sought to be carried out is an indication that the government and the people realize there is a demand inherently from the economy to have it. There has been progression even in enforcement. We have a federal setup, so states are supposed to enforce the IP law in terms of enforcement. And many of these states have actually brought in piracy as part of what they call a Gunda Act. So a bootlegger or a drug peddler is equated to a video pirater, and there is criminal punishment, in fact, leads to a jail without a remedy. In fact, all the southern states, most of the southern states, Maharashtra, Delhi, have it. If you, in that sense, and now we are seeing a new phenomenon where IP owners, we always had a very strong IP owner association for our film and music industry because that's a very thriving industry. And they have been associated with the police to see that raids happen and that copyright piracy is checked. But now we have a pan-industry IP owners association being created in some of the major industrial chambers. And the whole issue is, and rightly so, that the IP owners will become a stakeholder. They have been secret. The fact that there has been a unilateral increase in enforcement, something which is creating concern for us. the other aspect is the fact that I've mentioned earlier, that there's been an asymmetricity in the approach. So while you look at one aspect of IP, you do not look at all the aspects, which need to be looked at for a balanced agreement to be there. And I guess it should be agreed that rights come with a certain balance. They cannot be overriding rights. Another very important issue is that enhanced enforcements have costs on governments. And they also lead to efficiency losses in case they are absolutely increased enforcement levels. They've got to be suitably balanced in the context that I have already explained. You cannot discuss enforcement levels of increasing enforcement levels in such a non-inclusive manner where you're actually talking about a situation where it's a parallel system that you follow for countries that account for 70% of trade. Effectively, it will affect all the countries, all the member countries. And what we fear with the condition that it will be open for accession by non-member countries is extremely frightening. It means that you're going to use this as a handle in free trade agreement negotiations, which is wrong. You are using a position of strength to ask your trading partner to agree to it, to a situation which is unequal, because he doesn't have any role in determining the policy on enforcement. Thank you.
Well, thank you very much. I'll start with a few questions there, I think, from Chanya's presentation. Please, I would encourage you again, stick your hand up if you want to make comments at any point. Anyone who wants to equally ask questions, please do. And maybe start off with a point about having a plurilateral process rather than a multilateral one, and whether that harms things in the future. Would Jorge or Koji like to respond to that?
Well, as I understand, I think that TRIPS is the floor. It's not the ceiling. And that makes TRIPS, let's say, an agreement that was negotiated many years ago. And I don't see any problem in having this kind of ACTA agreement on part of IP scenario. This is enforcement, this is counterfeiting and piracy only. As I said, we do not touch any other rights in this ACTA agreement. We have another kind of agreements dealing in, let's say, WIPO, like the genetic resources, traditional knowledge and folklore, which is specific also, and many others. No? So, but I may say that this is not an obligation. This, I don't agree that ACTA will have or put some pressure in the new countries that would like to be a member of ACTA. This is a voluntary agreement. If you want to be part of it, do it. If not, don't join ACTA. And on the other hand, I think that we have also one very strong word, which is sovereignty. And we have sovereignty to deal whatever we want. So if we need this kind of agreement in order to enhance enforcement in Mexico, we will do it. And I don't care if we are NAFTA parties or with the European Union parties or with other or APEC member. This is a national decision. Of course, that the impact is plurilateral, because as you said, Madam Reina, we are talking about 70% of the economic production and everything. Okay, that's why we decided to go into ACTA. See, so that's what I think.
For one thing, the impact is not plurilateral. That's the sad part of it. It is multilateral. So you have a plurilateral agreement which discusses multilateral manifestations, which itself is asymmetric completely. It is not right. And the issue that whether substantive provisions are part of ACTA or not is a debatable issue, because as I highlighted, there are issues that are of concern to us, and substantive provisions are there. I'd like to highlight one aspect which is there mentioned in ACTA. It says that the ACTA agreement, the parties to this ACTA agreement can go beyond enforcement levels that are mandated in ACTA, as long as they do not violate the provisions of ACTA. Now here you have a completely shift. There is no mention of TRIPS. So you have a situation where you're just moving away, saying that now we have ACTA, we can go beyond ACTA as long as we are all right with, as long as we don't contravene the provisions of ACTA. This is a slow and steady movement towards higher levels of IPR enforcement, and in substantively also, countries like us feel that it is substantive as well. In any case, the fact that you've kept it secret, you have not discussed it, you have not allayed our fears in that sense. So now this is something that this is what we feel, and we've just happened to see the text in December when it was made public. So it is only since then that we're looking at it, and we are quite disturbed by what is happening. Thank you.
Yes, thank you. Regarding, I just want to make, say, maybe 2 points in this sense. First, is the TRIPS and ACTA are two totally different kind of framework, contractual framework. That's the question, the first question I want to address. In my view, in our understanding, ACTA is not something against the TRIPS. ACTA is building upon the TRIPS. Our aim is to stay, of course, all the members, participants into the ACTA negotiations are TRIPS members, and we will remain TRIPS members. So we will be bound by the TRIPS obligations, and that is the baseline. We build on the TRIPS principles. So let me just make reference to one very fundamental provisions of the TRIPS, and also fundamental provisions of ACTA. Article the TRIPS, Article 1, Paragraph 1, nature and scope of the obligations. This is from the TRIPS. Members of the TRIPS may but shall not be obliged to implement in their law more extensive protection than is required by this agreement. This agreement meaning TRIPS, of course. So the TRIPS members are, at the minimum, as George said, at the minimum implement in their law the minimum level of enforcement that is required in the TRIPS. But on the other hand, all the members of the TRIPS are free to implement more extensively. So they are free to implement TRIPS Plus. And if a certain number of members of the TRIPS want to implement TRIPS Plus, and in reality, including India, China, and many other developing countries are implementing TRIPS Plus in their national legislations. And if they want to do TRIPS Plus in their national legislations, why not do it more effectively and cost effectively, of course? That is one of the reasons why we wanted to start discussion about ACTA. If we want to do it TRIPS Plus, of course, as a national governments, we want to do it more effectively, and we want to find more efficient tools to implement more TRIPS Plus. And of course, since we remain TRIPS members, we also continue to be bound by the TRIPS, and the TRIPS flexibilities will remain among the TRIPS members. So another one article in that relation I want to mention is the Article 1 of ACTA. Nothing in this agreement, this time this agreement meaning ACTA, nothing in this agreement shall derogate from any obligation of a party with respect to any other party under existing agreements, including the TRIPS agreement. So the future members of ACTA continue to be bound by TRIPS. And so all the flexibilities, safeguards that are provided in the TRIPS in relation to other members of the TRIPS, non-parties of ACTA, will remain valid. So that's one thing I want to make clear. We are building on the TRIPS agreement, and ACTA intention of the ACTA members is to, since we sort of voluntary countries in the world, we want to make more efficient TRIPS plus enforcement. And if we want to make it more efficient, why not working together, building upon others' experience? We don't do it separately. So that is the purpose of ACTA, building on TRIPS. Another thing, just briefly on the second point, sorry. Yes. Are we going to work in a position of power over other members of the TRIPS? Of course, I understand the kind of fear that those non-participating countries to ACTA negotiations are surprised because it came out, and they have a lot of questions. That's quite natural. So I'm very glad that we have this occasion today, and this kind of occasion will need to be multiplied. But on the other hand, as George said, all the members of the TRIPS and ACTA, all of them are sovereign countries. So they will decide on their own whether or not to participate into ACTA or not. So thank you.
That's okay. I think we only have about 5 minutes, so I'd like to stay on this topic of the process of ACTA. I think Jorge had a quick comment, and then see if we've got some comments or questions from the floor as well, if that's okay.
Well, let me share with you some practical things that happened. And maybe that's another reason of why we decided, all of the countries, not to make public the text during the negotiations. And that is because we have a text full of brackets. Bracket plus bracket plus bracket. And then we have the US brackets, the Japan brackets, the Korean brackets, the Mexican brackets. We cannot make public this because only in the case of Mexico, we never will agree to publish the Mexican brackets because that's part of the negotiation and that's part of the strategy. So that's why we decided not to publish the text with brackets because no one, difficult for us to understand each paragraph full of brackets. And by 2 o'clock in the morning, you never know who put that bracket and what was the meaning of the bracket. And let me tell you one thing. We use one bracket in the Mexican case dealing with the ex officio powers for the Attorney General that we, of course, said never. We won't have it. So we have a Mexican bracket for months. But what happened? Suddenly, the Mexican Congress, approved the modification of the criminal code and gave ex officio powers to the Attorney General. So we came to ACTA and we delete the bracket. So that's very practical, no?
Good afternoon. I'm Pedro Velasco from the European Commission. Was negotiating ACTA for the last 3 years with my friends Jorge and Koji, and well, it was certainly very interesting experience. If I may comment on a couple of points raised by our Indian colleague, start to mention developing countries. Yes, that's quite a broad hat. It includes, inter alia, the country with the biggest scientific community in the world, with successful nuclear and space programs, with the biggest film industry in the world, which is certainly different from the Caribbean country with the lack of resources and with maybe no interest in these areas. On secrecy, that's quite an irritating cliche, to be frank. The text of ACTA was not made available in December. It was made available in April. By the way, the first version, the first time we had a text of ACTA, had been around the end of November. There was the gap, the entire secrecy thing was around between December and April, not to count with the many unfortunate leaks that we had. So there was little secrecy about it. But there is another hand. We are negotiating a free trade agreement with India. And recently we had a request for access to documents. And we, as we are bound by law, we identified the documents that belong to India, that had been sent. And we checked, as we must do with the Indian government, which opposed the release of all the documents. So it is not a strange thing in international negotiations. A level of discretion has to be kept. But let's be clear, all these processes then are submitted to very demanding democratic processes. They are approved by parliaments, by our member states. It's secrecy. Let's talk a little bit less about that. There are so many points I would like to raise, but I will just come to the impact on multilateral to remind, when you do these issues for too long, like maybe I have done, we tend to have long memory. And I remember years before ACTA, when we went to the TRIPS Council and put enforcement on the agenda to discuss best practices, to present our cases. So not talking at all about improving or changing TRIPS or having new legislation. I remember India blocking this point from the agenda several times. So I think that certainly harms more multilateral when we are afraid, when we prevent partners from discussing the issue. Ultimately, partners, as kids say, they pick the ball and they go and play in their own corner. And they come to an agreement that bounds them, which will not have an effect on India. On this story of generics, let's stop turning an incident that happened 3 years ago into a goal of ACTA. There is nothing in ACTA that will prevent generics. It's not a goal at all to prevent circulation of generics. Generics are essential. Europe has an enormous industry of generics. It's for our health systems, they are absolutely necessary, as they are for India or for Brazil or for Africa. There is nothing in ACTA that will affect generics, and you know very well that these incidents have not been repeated. All caution has been taken that they don't happen again. So I know this is a catchy issue, but it's not the reality of ACTA. Thank you.
Thank you very much. I think we have... I think we've officially run out of time, but I think we have time for just one more comment there, and then I will even have to leave it at that.
Thank you, Mr. Chairman. My name is Horacio Rangel. I am a partner in the Mexico City law firm Rangel y Rangel, and I am head of the chairman of the International Treaties Committee within the Mexican Bar and the Mexican group of AIPPI. Therefore, in the Mexican group of AIPPI and in the Mexican Bar, there has been an interest in the way ACTA has developed and was adopted. I do not agree, but I do respect the secrecy and the reasons for which negotiations have been kept secret. What I cannot share is the continued secrecy of those negotiations. I submit that it would be very useful to have published in internet, in a web page, the conditions in which a provision was adopted the way it was adopted. It has a definite impact in the way the provision is construed. Before TRIPS was drafted, the way international intellectual property treaties were drafted was clear. Clarity was always the rule. In all intellectual property treaties, I know with no exception. There are some treaties which are more complex than others, like PCT is more complex than Paris, but both are clear. This clarity is not continued when the TRIPS agreement was drafted. And the reason is that an ambiguous text was needed in order to give room for different interpretations. Well, this is understood when an international, a multinational agreement is being negotiated. But here we had the United States, Japan, and Europe as majority members negotiating also with Mexico and Morocco. I wonder why the ambiguous texts that are present in TRIPS are repeated in ACTA, but ambiguous text is already there. Since ambiguity is in the text, then one needs tools to interpret the ambiguous provision in one way or another. So my request is that these conditions, the minutes and the conditions in which a provision was adopted, be published. This is one statement. The second brief statement I want to make has to do with an opinion that has recently circulated around the world, an opinion drafted by a group of European scholars, professors, some of them, who have attacked the text of ACTA for various reasons. One of these reasons is, two of them I will point out. One of them is that ACTA goes beyond TRIPS. This has already been discussed by our Indian colleague, and I will not insist in that. And our Mexican colleague has also explained the reasons for which parties are free to do that as members of the Paris Convention. Article 19 of the Paris Convention allows that. But the topic that really concerns is the critics on the ACTA provisions, the criticism expressed on the ACTA provisions by reason of being in violation of human rights, according to this opinion by European scholars. I wonder if European scholars are aware that the target of these provisions is organized crime. I agree that human rights pertain to the human race, regardless of whether they are criminals, organized criminals, or street robbers. But I was surprised to read such a defense in favor of organized crime by raising human rights issues in this opinion drafted by the most distinguished scholars I know in Europe. I wonder if the officers involved in ACTA have an opinion on that opinion made public by the European scholars a few days ago, actually. Thanks very much.
Thank you. We're already quite a bit over time. I think no matter when we stopped this discussion, we would always have other points to make and other questions. So perhaps it's a session that should be given twice the amount of time that it actually had today. I think maybe the people involved could address those after we leave, but I think we'll have to cut it short there. I'd like to say a big thank you to all our speakers today for coming along and for giving their presentations, and thank you also for being here. Thank you.
Thank you very much, Simon, and thank you, Reverend, ladies and gentlemen. The following session will be dealing with securing the supply chain. For those of you who are interested for the power of education and awareness in building respect for IP, this one will take place in the other conference hall. I ask you to start on time also and to finish on time, since we have the glossary plenary afterwards and we have quite a tight schedule. Thank you.
Thank you very much.